Good morning, Your Honors. Drew Justice for the appellant, Gavin Clark. I'll reserve 5 minutes. And what I'm going to do in this argument today is try to focus and start out on a set of 2 or 3 issues that all revolve around one theme. And that theme is the judge refusing to take a stand, refusing to rule on the relevant issues, and ultimately passing the buck on to others. And then if we have additional time, and depending on what your all honors wish to talk about, we may cover some other issues. But the 2 or 3 issues involving failure to take a stand involve one, this issue within the McDaniel claim, this issue about the judge was supposed to serve as gatekeeper. He was supposed to make a ruling on whether this science had any kind of validity at all, whether there was too much of an analytical gap. And instead of doing that, he basically passed the buck on to the experts to just say, y'all have some experience, I'm going to let y'all and the jury figure it out. 2, within that same basic issue, he passed the buck onto the state about whether we would even have a pretrial McDaniel hearing. And then 3, once the defendant was convicted, once we got to the 13th juror phase, the judge again passed the buck and said, I'm going to defer to the jury under the Jackson versus Virginia standard. Now, on this McDaniel motion, ultimately, the biggest problem with the McDaniel motion was that the judge, there were 2 different problems. One, he refused to rule on whether we were even going to have a hearing, and then once we actually got to the hearing, if you can even call it that, he ultimately refused to rule on whether the science was valid.
Okay, so you raised that issue as your first issue. What was the prejudice to you? Assuming that the trial judge basically collapsed all the steps that you're normally supposed to go through in determining, what the expert witness qualifications, all of those steps that we require for admissibility of expert testimony. What was the prejudice to you? Because my understanding is you received CVs, all the experts, 6 months in advance. You knew what their opinion, i.e. hypothesis, was going to be. You knew what they were going to be or anticipated to be testifying, the area in which the state was submitting they were experts in. My question to you is, what's the prejudice to you here?
Well, with regard to Your Honor's understanding of the facts, we did not, I don't remember when we got their CVs, I'm not sure about that.
But 6 months in advance.
But we definitely did not know generally what their testimony was going to be or what their opinions were going to be, other than Dr. Lowen. I think we got like a more formal kind of report for her. It may have been a few months in advance. I don't remember exactly when. The others we did not. And so ultimately, the way we were prejudiced by not having the hearing was, one, the judge didn't get to make any kind of collective analysis by looking at all these experts.
What would that have done?
Well, Dr. Betters testified that a single blow could cause multiple injuries. Dr. Lowen testified that it could cause 2, but they had to be, and that they could be disconnected. Dr. Carney testified that you could have multiple fractures, but that they all had to be connected, like a radial set of fractures. Dr. Turnbull, I don't remember if this was in the voir dire or in her ultimate trial testimony, but she started out by saying you can only have 1 fracture from 1 blow. And then when I told her what Dr. Lowen had admitted, then she changed her testimony and admitted that it could be 2. And so when you have these doctors that are contradicting each other, who are not only not really explaining their reasoning in any scientific way, but who are outright contradicting each other, the judge should have gotten to look at that collectively. Further, there wasn't any opportunity for us to rebut it with our own science or other witnesses. And so he could have, if we'd had one hearing, he could have heard our expert, Dr. Hunsaker, testify that, yes, you can have multiple different disconnected fractures from a single blow. And then getting back to Your Honor's earlier point, we were expecting this hearing to basically serve as a point of discovery. And we had avenues wherein we could have gotten discovery elsewhere, and I don't really know to what extent this is all in the record, but I mean, he had an open juvenile case to where we could have deposed these witnesses if we wanted to.
I'm legitimately asking because we do see in the criminal world a lot of collapsing of the steps for McDaniel's admissibility of expert testimony, but we rarely see, someone establish prejudice as a result of that. So I just wanted to see, I don't know that I saw that really stressed in your materials, although you gave us a lot.
And
But, go ahead.
maybe somewhere in that lot that you gave us, this is in the in your briefs, but before these experts, I mean, there was a McDaniel type hearing, but it was at trial, right before they testified. Is that correct?
I mean, I would view a McDaniel hearing as where he looks at it all collectively.
I
And so
understand
in that
what-
sense, there was not.
But there was a hearing where the judge declared them to be an expert and allowed them to testify.
In a sense.
Did you have reports? There were reports prior to that? But
We had a report from Dr. Lowen, and then we had medical records from at least, yeah, I think we had medical records, and then we had a report from the forensic examiner, but it didn't really explain itself or give any reasoning in it.
But there were records or reports that you could turn over to your expert and say, take a look at these and tell me if they're correct or they're not correct, or how can we attack these?
To some extent, but again, they were very skeletal.
Okay.
And then getting to more the root of the McDaniel error is just that under the judge is supposed to give his reasoning for whether this science has an analytical gap that's too great or whether it doesn't. And under both the U.S. Supreme Court and the Tennessee Supreme Court, in applying their respective evidentiary rules, they both said that the ipsa dixit of an expert doesn't cut it to satisfy Rule 702, 703. And ipsa dixit means he himself said it. And so it basically means that's a really smart person. He's got a lot of experience. He says it's so, so it's so. And that doesn't cut it under the rule, but that's what we had here. Here we had Dr. Betters, who the judge just said that I'm going to he said he was going to admit her testimony because of her qualifications. He said principally because of her academic credentials and her clinical training and experience. So no reference to the actual logic of what she was saying or whether he thought it made any sense. With Dr. Lowen, there really wasn't any explanation other than the judge did at least cite McDaniel. So I mean, he gets a point for that, but he didn't actually really identify the principles of McDaniel. And then in Turnbull, the judge again just referred to her knowledge generally and her experience and her associations with other doctors. He just said, I'm allowing the testimony because of her bank of knowledge, and that was something he elicited himself under his own leading questions over my objection. And then in Dr. Carney, the last one, he gave no explanation at all. He just said, yes, I'm going to allow it. And so ultimately, the judge to survive an abuse of discretion appeal, the judge is supposed to identify and apply the most appropriate legal principles. Here, the judge did not do that, so the judge abused his discretion, and that applies for both the ultimate conclusion and for whether we're going to actually have a hearing on September 14th, which initially he said we were going to do, and then just because the state didn't want to do it, he just gave them that. Ultimately, the judge is supposed to serve as gatekeeper to decide whether the science is valid at all. As gatekeeper, he's supposed to keep pseudoscience outside the gate. And because he did not do that here, he erred, and therefore the court should reverse on that issue. Next, on the 13th juror issue, the judge was supposed to make up his own mind as to whether Mr. Clark really did this to his child, whether he was really guilty beyond a reasonable doubt. And ultimately, he just failed to do that. He said, I'm looking at the Jackson versus Virginia standard, which has been the standard of review on weight of the evidence for 50 years in this country. If there's any credible admissible evidence supports the evidence from which a jury may infer guilt, then that standard is met. In my estimation, that standard was met in this case. And so he's, again, citing the wrong standard. And I would agree that, especially on the abuse claim, I don't agree the evidence was sufficient on the neglect-based charges, but on the abuse, I mean, they had some witnesses who were saying this child had to have been beaten, so there was sufficient evidence from which a rational jury, I guess, could convict, although
So
it
is
was
there
weak.
anything in the record other than him citing the wrong standard of review
The only
to
other,
indicate that he abdicated his duty as the 13th juror, or that he was confused about his role as a 13th juror?
what I was citing there was the transcript from the oral ruling on the motion to suppress. In his written ruling, he said basically the same thing. He cited Jackson versus Virginia again, and there he arguably made things even more confusing because he referenced a great weight of the evidence standard, which is a real standard, but it's the federal motion for new trial standard, basically.
So you, again, just relying solely on his citation to Jackson, the wrong standard of review.
Right, but under Jackson versus the 13th juror standard, and you can only overrule under the great weight of the evidence if the evidence heavily preponderates against the juror.
Okay, talk to this panel about our Tennessee Supreme Court's most recent opinion on the 13th juror and whether we should consider that in our review of this issue.
Well, I had already gotten my brief mostly ready, I think, when that came out, and obviously that could potentially wind up biting us somewhere down the road, but I didn't spend a lot of time on that issue in my briefs, and neither did the state, because I don't think this court really has the authority to expand that rule. It's conceivable, although I don't recommend it, that the Supreme Court could, so I don't think this court can really deal with that.
Okay.
And then the state, to sort of get around these two, we have to keep in mind that the rule on 13th juror is supposed to be that the ruling has to be clear and unequivocal that the judge actually applied the right standard. Here it's, I think, pretty clear that he applied the wrong standard, but it's definitely, at worst, or at best, it's equivocal. And so we should get relief.
So what the state's arguing, and what we have some cases in this area, murky, but we have cases where we have looked at the sentencing hearing to see and to get, I guess, some idea of whether the trial court, I guess, agreed with or acted as the 13th juror. And in this case, if my memory is serving me, at the beginning of the sentencing hearing, even taking the enhancement factors relied on by the state here, the trial court talks about agreeing with the jury's verdict here. You know what I'm talking about?
You're citing,
In the sentencing hearing, at the beginning of the sentencing hearing? You don't know what I'm referring to?
I don't know,
Okay,
I
that's
don't
fine.
know of that exact language. What I had gleaned from the passage that the site had stated was that the judge applied a couple enhancement factors, and the reason he said those enhancement factors applied was because there was evidence that the defendant concealed the injuries, and also that there was evidence that the child was abused over and above what was necessary to kill him, basically.
Do we know if the trial judge was making an independent determination whether those facts were shown, or was looking at the facts in light of the Jackson standard in making the determination with regard to those circumstances or factors at sentencing?
As far as I'm concerned, we really don't know, and I don't think the judge really said. I will say, as far as I saw from the transcript, the judge never did say he believed that the defendant was guilty.
Was he required? Never mind.
And then what I had pointed out too is, as best I can tell, the case law allows for enhancement factors just based on a preponderance of the evidence anyway. And so even if he did say, I believe it, I believe it by a preponderance, that really wouldn't jive with the 13th juror standard. And it looked to me like the cases the state was citing for even applying sentencing comments, it seemed like those were all cases where the judge at sentencing made comments that made it even more confusing about whether he agreed with 13th juror. I didn't see anywhere he gave a bad ruling at the motion for new trial, but then the state was able to save its conviction by pointing us to sentencing.
I see that you're about to run out of time. I wanted you to address the ambiguous verdict forms. If you could spend about a minute to two on that issue, because that is a question I don't think that this court has seen before.
I don't think this court's seen it before. I don't think Tennessee at all has seen it before, but I did cite a Sixth Circuit case, a Second Circuit case, and then an Arizona Court of Appeals case talking about where if the jury disagrees with itself within a count then that is enough to nullify the verdict. And here we had Mr. Clark being found guilty of aggravated child abuse, but also not guilty of child abuse.
Can you speak to me about what happened when the verdict form was passed to the trial judge? Because my understanding from the briefs, the verdict form was passed to the trial judge, approved, and then the jury verdict was announced, the jury was released, and you subsequently reviewed the verdict form at sentencing.
I reviewed it once the pre-sentence report came out because the pre-sentence report officer attached it to her report, and that's when I first saw it. And so I think when the jury orally announced their verdict, they just focused on that top one, the one that I'm trying to overturn, when they said he's guilty of aggravated child abuse. But they didn't mention the second part where they said not guilty of child abuse. It is the exact same issue as in the Arizona Court of Appeals case, and then the two federal cases I cited are not 100% the same, but they're very, very similar, involving a verdict followed by a special interrogatory, which is the same basic thing as what we had here.
What is the remedy for an ambiguous verdict?
Well, as far as I can tell, it ought to be a new trial. But I did see, I think both federal courts said that the proper remedy was just to acquit. And I, would like to be able to argue for why I think that's a good idea and we should just acquit Mr. Clark based solely on that. But honestly, I couldn't come up with anything all that strong, so.
All right. Thank you so much, Mr. Justice. I'm losing my mind. Counsel.
Hello again, Your Honors. Alan Groves on behalf of the state.
Yes.
I will limit my argument this morning to the issues identified by defense counsel and the court, so I can be responsive to what's been discussed already. So beginning with the issue of expert testimony, Judge McMullen, this court's case law is pretty clear that the trial court has a discretion about when to hold a McDaniel hearing. It can happen before trial or it can happen during trial, as was the case here. Defense counsel kind of characterizes the trial court's decision as just passing the buck to the state or just kind of giving the state deference about when that would occur. But I think if you look at the record, it'll show that the state was just having some scheduling difficulties with the 4 different expert witnesses that it intended to call at trial, including a forensic examiner that had more limited availability based on the number of criminal cases that she was involved in.
So there are a lot of steps in a McDaniel's hearing. Did the trial court follow those in the hearings that were held immediately preceding? Was it just pre-trial or pre each witness's testimony?
It was pre each witness's testimony, kind of in a voir dire context, or voir dire. And I think that's important for the court to understand, because these hearings, although they were conducted separately, they're all kind of building on each other, because 3 of the 4 experts were all admitted as expert witnesses to testify about pediatric critical care. So their testimony was very similar in many respects, and the trial court was hearing the same types of testimony in each of these little mini hearings during the jury outs. And so I think that's relevant as the court is considering the level of specificity of the court's findings. And the state will acknowledge that for some witnesses, the factual finding for the factors were more specific than others. As defense counsel mentioned, I think in Dr. Lowen's testimony during her hearing, the court specifically referenced McDaniel, indicating that it was considering the McDaniel factors. It didn't expressly cite the case in every hearing, but it was clear based on a totality of the record that that's what the trial court was concerned with. And I think each of the witnesses testified that this medical diagnosis of child abuse or non-accidental trauma was generally accepted in the scientific community. That was consistent amongst all the witnesses. And our courts have recognized as well that the McDaniel factors are not applied robotically, and sometimes the factors might not even apply depending on what type of scientific evidence we're talking about. And here, like the rate of error, for instance, we wouldn't expect to see like a percentage that some study has accounted for what the rate of error would be in diagnosing child abuse. But even with respect to that factor, you had one witness testify to her personal experience that she had only been wrong a couple of times, and it was in the defendant's favor. So the court's listening to all this testimony in these different jury out hearings. It's obviously considering McDaniel, which it's cited at least once, and it's acknowledging that each of these witnesses had the academic credentials, but certainly that was not the only thing that the court was considering. It definitely heard the testimony about reliability, which is the next biggest factor, and the court is hearing this testimony that it's scientifically reliable, it's generally accepted in the community, and if, obviously I would like to have more factual findings in any appeal that I'm handling, honestly, but particularly in this case. But this court's decision in Gardner from last year really emphasizes when it comes to this particular type of expert testimony, which in that case I believe the experts referred to it as battered child syndrome, that has been generally recognized by both our state courts and the United States Supreme Court for over 50 years as being admissible in evidence. And so when we're dealing with that type of settled that type of evidence, we give the trial courts a little bit more slack when it comes to making these specific findings about scientific reliability. And I understand that these specific witnesses in our case did not call this battered child syndrome, but I just wanted to read the description from Gardner when it's describing what that is. It's a series or pattern of injuries that suggest child abuse rather than accidental harm, which was the defendant's theory in this case, due to the type and unexplained nature of the injuries. It seems to fit exactly what these experts were testifying to. And so Gardner says that when that's the type of evidence we're dealing with, we're not going to hold the trial court to quite as strict of a standard in terms of the specificity of its findings. So I do think the trial court properly exercised its discretion by holding the McDaniel hearings when it did, based on the scheduling availability of the state's witnesses, and also in making the appropriate findings. Regarding the 13th juror ruling,
General, on the 13th juror issue, the trial judge both orally and in writing references the Jackson standard. Why don't we just believe the trial judge that the trial judge looked at it in light of the Jackson standard, which wouldn't be the right way to look at it?
Sure. I think if you look at what the trial court actually said, it said the great weight of the evidence supported the jury's verdict. That is what it was required to find as the 13th juror. So I think we should take the trial court's words for what they are. It applied the weight of the evidence standard. Obviously, it cited the wrong case in terms of explaining its decision. And again, I wish it had not done that. It would make it a little bit cleaner. But I think we can look at, again, the totality of both the transcript of the motion for new trial hearing and the written order denying the motion for new trial, and we can see that the court did separately analyze sufficiency of the evidence and the weight of the evidence. And so I think that's further evidence that the court did understand that it had this duty to act as the 13th juror in a way that's separate from evaluating the sufficiency of the evidence under the Jackson standard. It does make it a little bit more complicated that it has that citation error at both the hearing and in the order, but it is addressing these issues separately. So, I did drop the footnote about the Supreme Court's decision. We're not asking the court to get ahead of the Supreme Court in any way in terms of extending that to criminal cases. We recognize that was cabined to the civil context.
But they cited Moats throughout the entirety of the
They
opinion.
did. So I think that would bode well for us, but I would never want to predict what the Supreme Court would do. But it was citing, I think, Justice Schroeder's dissenting opinion. But we don't think...
One of the things about 13th juror that's always it's been an issue with me, and I've written before in opinions, that when a judge signs a judgment, isn't that his acting as 13th juror? His or her acting as a 13th juror?
So our courts have held that if the judge is silent about the 13th juror ruling, for instance, by just entering the judgment without making any kind of commentary, that we do presume that the court acted as the 13th juror. But it's only when the court expresses dissatisfaction with the verdict, or, which is relevant here, maybe that it misunderstood its responsibility or authority to act as the 13th juror. That's when we have to look a little bit more carefully at it.
And it's his citing this wrong standard that's the problem here.
That's what the defendant's arguing. But
Okay.
I think we should...
Problem. I mean, it puts us in an uncomfortable position of having to figure out whether he understood what his role truly was.
That's the issue before the court. And there's really three prongs of my argument here. First is look at the words that the trial court used. The great weight of the evidence supports the jury's verdict. Correct. Check mark. It understood its role. I don't think that's a reference to the federal standard. Nobody suggested that below. There's no citations to like Sixth Circuit precedent or anything like that. Number two, the separate treatment, as I mentioned with Judge Usman. It's analyzing sufficiency under one heading in the order, and then it's analyzing weight separately. That's the second prong. And then the third...
But that's because that's the way it was presented in defense counsel's motion for new trial.
Yes. But that shows that the court's being responsive to each issue. It's addressing sufficiency first, and then it's addressing weight. So that's our second argument. The third argument, as you mentioned earlier, Judge McMullen, is sometimes this court will look at sentencing to see, is there anything we can glean from the transcript to assure ourselves that the trial court really did agree with the weight of the evidence. And I'll acknowledge that when you're talking about application of enhancement factors, sure, the court's only required to find those by a preponderance of the evidence, but I still think it's relevant here that the court found that this defendant and it didn't say it was only by a preponderance, it could have found this enhancement factor beyond a reasonable doubt, but that he treated the victim, his 5-week-old baby, with exceptional cruelty. That does not seem to be an enhancement factor one would be likely to apply if you really doubted the weight of the jury's verdict and the weight of the evidence. And I'm not asking the court to draw any bright line rules with respect to sentencing, because I think surely defense counsel would agree if the trial court said during a sentencing hearing that I agree with the weight of the evidence and beyond a reasonable doubt I would have found you guilty. Certainly the court could consider that even though it's at sentencing. Maybe that's a little bit less, maybe our argument carries a little bit less force because we're talking about an enhancement factor under this preponderance standard. But again, I still think it's relevant as we're trying to understand holistically what did the trial court understand its role.
A little bit of a tangent for you.
Sure.
The search warrant in this case. Essentially, we've got detailing related to abuse, circumstances that lead the police to believe that there's abuse here. And then we have a statement essentially by officers that people commonly use cell phones in these types of cases. Isn't the search warrant essentially just one that says, hey, it's a child abuse case involving a parent, so therefore probable cause with a cell phone? And how is this warrant different than that? What is the particularized showing here?
Yeah, this search warrant affidavit also is not one of the most precise warrants that I've seen for getting cell phone evidence. But I think still, if you look at the whole affidavit in context, it says...
Where does it say that the cell phone has been used? I didn't see a reference to there was a message, there was a call, there was a communication. There was a statement that, kind of like, we expect to find evidence. Well, that's great. I mean, what's the basis of your conclusion that you expect to find evidence? I didn't see that where there was that phone call or message. What's the linkage?
Yeah, there's no direct reference to cell phone usage, but I do think that there's a reasonable inference. When the affidavit said that Savannah, the mother of the victim, agreed to hand over evidence of the alleged crime, which was to include the defendant's cell phone. She just had a police interview where she's gone in and she's telling them what she knows, and then immediately after that description in the affidavit, it said she agreed to hand over evidence of the alleged crime, which was to include his cell phone. So I think the implicit...
What evidence, though, in making a determination to issue a warrant, what evidence is that the trial judge is being told is going to be on there based upon that statement? I mean, again, there's not there was a phone call, there was an email or text, there was what's the evidence you would expect to find?
So I think because there's a pretty lengthy description of the investigation up until that point, and it was clear that the defendant had sole care of the victim at home when this abuse occurred, and that the mother was at work at the time. And the implication from this sentence in the affidavit is that there were communications between the defendant and the mother. And when she goes in for the police interview, it's a reasonable inference to draw from the affidavit, reading it in a common sense manner, as the court's required to do, that she told police there were these communications, there were text messages, there were phone calls between us when we were concerned about the
You would
child's
agree
health.
that there are no statements to that effect?
There are no direct references to cell phone use. We'd have to rely on reasonable inferences drawn from the affidavit. But regarding the suppression issue, we think there's a strong harmless error argument here, even if the court were to find that the search warrant affidavit was not supported by probable cause. And that's because the mother did testify about the text messages and the phone calls. So the actual data that was recovered was not necessary to support the verdict because we had testimony.
The searching of the medical sites was used by the defendant in this case to the defendant's favor too. That's the thing you wouldn't have through mother's testimony, right? Is the searching.
The internet search history. Yes, I don't. Yeah, his theory was that this was an accident. I attended to the baby and then calmed him down, and then I started searching things online to see what I needed to do or if he was going to be okay. So he did affirmatively use that evidence. And in light of the expert medical testimony as well, this cell phone evidence would not have contributed to the verdict. No reasonable juror would have accepted this defense in light of the overwhelming medical proof that we had here.
But do we have a valid verdict?
Regarding the ambiguous verdict
Yes,
claim,
I mean, that's just very fascinating to me to see the jury totally disregard the trial court's instructions on acquittal first. What we know is our acquittal first jury instruction, and go down and find not guilty each of the lesser included offenses or one for the reckless homicide. That's troubling to me, and you know, I've read the cases in both parties' briefs, and I don't see how defense counsel could have waived it by not polling the jury, because the trial court is who looked, I'm assuming looked, that's why I asked about the practice. That's when I'm dating myself. When I was a prosecutor, the trial judge would review the verdict form before announcing what, or passing it back for the jury to announce, to make sure it's in order. And I think that's what occurred here, if I might be, it's late in the afternoon. So tell me, do we have valid verdicts here?
Absolutely. And that is a accurate summary of the record. The court did look at the form and handed it back to the bailiff for the foreman to read and announce in open court. We did advance a waiver argument that the defense counsel still could have requested to look at the verdict form. And I take the point that...
So what the message should be from that argument is that every defense lawyer should now individually poll, as well as request from the trial judge to review the verdict form to ensure that it's in proper order so they don't waive this issue?
It would have been an available option for the defendant. And when the foreman is announcing a guilty verdict, that puts the defendant on notice that there's at least a strong possibility that they found you guilty.
But
and if you have...
You mentioned in your brief that we presume jury follows instructions. And wouldn't the presumption from the defense attorney have been that the jury had followed the instructions? And so by finding guilty of the higher level offense, you're not going to have a not guilty of the lesser included offense. I mean, we presume juries follow their instructions.
And on top of Judge Usman's comment, I don't know which side raised it, but what is the polling going to do? Just confirm that they agree on the greater charge? It's not going to disclose any information about finding the lessers not guilty. That's not what polling is.
Yeah, and I take the point that defense counsel also raises in the brief that polling usually goes more towards verifying jury unanimity and maybe not so much certainty of the verdict. But I thought really hard about this, and I still do think that it makes sense to poll the jury in this context. And the reason is because how I understand the defendant's argument is that we don't actually know what the jury's verdict was on the greater offense because of these other markings on the lesser included, because it would be inconsistent to be guilty of the greater and not guilty of the lesser. So really we don't know what the jury's verdict was on the greater offense. But if you polled the jury and asked the jury, are you really sure that he's guilty of the greater offense? And they all said yes, we would know with certainty that is their verdict and that the remaining markings are just mere surplusage. which is what we argue. So I do think a poll could cure that error in the form, but I'm perfectly happy for the court to reach the merits if it disagrees with our waiver argument.
Okay.
Because I
let's go
think
to the merits. Let's go to the merits.
yeah,
'cause
I think a common sense understanding of this form is that the jury followed the order of consideration instruction by starting at the top and finding him guilty. And I acknowledge that they did go beyond that in making additional markings on the not guilty for the lesser includeds. But that's not necessarily evidence that they considered those lesser includeds, like
what
on
other
the
evidence
merits.
do we what else would we do to get evidence other than the verdict form? I don't see how the state can argue we don't have evidence that it's inconsistent of what the jury did. They blatantly disregarded the court's instruction not to go further after they reached a verdict on the greater. And I don't see what other evidence we could have than the jury verdict form.
So a lay person that is not trained in the law is not going to understand this legal nuance that if you're guilty of the greater offense, you're necessarily going to be guilty.
But that's what they were instructed to do by the trial court.
Yes, and they did find him guilty, and I think the court can reasonably construe the additional markings as surplusage of the jury just indicating that we are not considering the remainder offenses because we found him guilty of the greater offense.
General, one thing I'm struggling with your argument on that point is it seems to lean pretty heavily on the presumption that juries follow in their instructions. But here, we know the jury didn't follow its instructions, and so you're asking us to say, disregard, ignore those markings because we presume that juries follow their instructions in terms of top level, and then they stop and they don't consider, and then it's just surplusage and marking. But this same jury was told that, and highest level first, and stopped there and proceeded to do it anyway. And so I'm struggling with how exactly do I take this presumption the jury follows its instructions, and which exactly am I supposed to presume? That it followed its instruction with the top level, or that it followed instructions and not marking when the others weren't relevant? And you're putting a lot of weight on presumption that the jury followed instructions. In a case where the jury, we know absolutely did not follow its instructions. And so it either shouldn't have marked the lower level offenses or shouldn't have marked the higher one. But it's, how do we put the weight that you're trying to put on presumption given what we're looking at?
May I respond, Your Honor?
Yes, you have. We've taken a lot of your time.
Yeah.
Please do.
And it's an interesting issue, and
Yes.
I've never seen it before in our courts either. I think the court can still rule in our favor without the presumption. I didn't intend in my brief to suggest that our argument turns on that. Okay. But I do think it's noteworthy that the only case the defendant has been able to identify where this issue occurred and came out his way was in Arizona, where they don't follow the order of consideration instructions, and you can move to the lesser includeds just after making reasonable efforts to reach a verdict. So I do think that's relevant.
Why is that relevant?
Because if you're following our instruction, which I do think we can still presume they followed it, and I understand I'm getting resistance from that from the court, but I think there's a way to reconcile what happened with the actual instruction. You can presume that they started with the top, they found him guilty, and they did not consider the lesser includeds. Pursuant to their instruction, they just marked not guilty to indicate that they weren't considering anything else. I do think that's a reasonable way of construing this verdict form.
And I know in I think it was your brief, you argued cases that set forth a common sense approach to a verdict that seems to be inconsistent. And to me, that's like common sense. What you're arguing right now, common sense would dictate that they said he's not guilty of the lesser included.
And yes, and again, thinking about it as a lay person would, I found him guilty of one offense, and I'm not finding him guilty of these other offenses is the most common sense way to approach it. I'll also just emphasize very briefly that in the Sixth Circuit, these other cases that the defendant's citing where this has come up, these are drug cases where there's clearly an ambiguity when the jury's finding someone guilty of a drug offense, but then when they have to identify the quantity of the drugs, they say 0 or none.
Well, those are special verdict forms. That's not the same as
Exactly.
what we have here. I'm talking about Hansen
Mm-hmm.
and the Arizona case.
Mm-hmm.
And that is, I think, almost precisely like what we have here, except for the fact that the jury foreperson tried to explain it was my error before the trial judge cut him or her off because they didn't want to get into the deliberations. And that's why you have the dissent saying it's a common sense and understanding, because the juror was trying to explain to you what was going on here. We don't have that here. We don't have any of that here. We have the trial court looking at the verdict form, presumably maybe not really seeing the boxes under the greater checked not guilty, and passing it back and letting that verdict form stand. And that is troublesome to me because it's not a verdict.
Well, Your Honor, I'll disagree with that last point. I do think it's very clear that the jury found this defendant guilty of abusing and neglecting his 5-week-old baby, and we would urge this court to affirm those convictions. We certainly don't think that reversal would be the remedy.
What would be the remedy from the state's
I
perspective?
mean, our alternative argument, I think, would have to be a new trial. I'm not sure that a remand would be able to accomplish anything at this point after the jury has been discharged, but we haven't briefed the remedy issue, and if that's something the court was seriously going to consider, then we'd...
I think that's part of the issue raised. Mr. Justice clearly raised the ambiguity in the verdicts and cited the cases. I don't...
He's not asking for reversal, though. I think he conceded at oral argument that he's not asking for an acquittal.
Okay. Well,
He's
we'll let
asking
him
for
speak
reversal,
on
just
that.
not acquittal.
Okay.
Okay, that's what,
Okay.
you're saying then the remedy would be reversal back for another trial?
I think so, Your Honor.
Reluctantly, you're saying.
Yes, I'm not aware of all the range of options that we would have in this scenario, but we do urge the court to affirm these
Thank you
convictions.
so much. We've kind of grilled you today, so.
No problem.
But thank you for your argument and your brief.
Thank you, Your Honor.
I think you've got 5 minutes, Mr. Justice.
And on that issue of the remedy for the contradictory verdicts, I think in my brief, I mean, I've allowed for the idea that we could just get it reversed and dismissed based off that, but both the federal cases did that. The Arizona case I don't think did, and when I tried to study it to figure out which one was right, I couldn't really understand why the federal courts did that, so I tend to agree with opposing counsel. It seems like a new trial makes more sense, but I'll let y'all decide that, I guess. On the issue of whether the Fourth Amendment issue was harmless error, it was brought up that Mr. Clark commented on some of the illegally seized evidence, and I would just submit that the state introduced it first. They introduced it for an incriminating purpose to try to show that he had knowledge that his child was on the verge of death, which would help them prove their aggravated neglect charge, and that without that, they arguably didn't have any evidence of his state of mind for the neglect. But
Opposing counsel references the idea of a reasonable inference based upon the statement that the phone was being turned over as evidence. Why, in your view, is that not a reasonable inference? I'm assuming you view it as not a reasonable inference. Why isn't it?
it's not a reasonable inference because it's just totally bald, and it just really jumps the shark from what the officer's actually saying. Like, I mean, if we were to allow that, it would basically just, if the police want to be able to seize everyone's cell phone, we could amend the Constitution to say the police are allowed to take out general warrants for the purpose of seizing cell phones anytime they can show that someone owns a cell phone and committed a crime. And that's effectively all they did here. Just saying that the defendant's wife agreed to cooperate with the police does not create any kind of inference that she knew any evidence, good or bad, was going to be on that phone. It just means she's a nice person and cooperates with the police officer. And
So
then-
because as I understand the state's argument too, there's a harmless error on argument here. How do you respond to that? Because the wife did testify.
The main reason we were saying the cell phone evidence was harmful was because of the website searches, and the state brought that up in their case in chief, and then they also argued it, and that was part of one of my claims about the improper arguments was them arguing over the websites from the cell phone. But I would say they were using the websites from the cell phone to show that Mr. Clark's guilty state of mind, especially for the neglect, about which they had virtually no other evidence to show that he knew that his child had to get help. And so they used that to prove that. And so I would just say the state has to prove beyond a reasonable doubt that the error was harmless. And I'm not saying that this is the most damning evidence against my client. I would submit the evidence as a whole in this case makes my client look innocent. But if anything, the fact that the evidence used to convict him is weak, that's supposed to weigh in favor of showing that the error was harmful. And so because the evidence was weak and because this was used by the state to prove his state of mind for aggravated child neglect, I would just say it was harmful. And to the extent that he talked about it himself, he was just responding to their having already gotten into it. In terms of the court having discretion about when to hold a hearing, I mean, we had set this hearing initially out, I think we set it in March or April. We set it for September. So for September 7th. So the state had 6 months to get ready for this McDaniel hearing. They didn't get ready for September 7th. On September 7th, they told the judge, in essence, we're not ready. And then the judge said, okay, you can have one more week. We'll come back on September 14th. And then they said, if you have trouble getting them here, you can either file affidavits or have them testify by Zoom. And they didn't take either of those options. Instead, they just came to court again and said, in essence, we don't want to have a hearing. And the judge just let them do what they want. And that's why I say the judge was passing the buck on that. He has discretion about whether to hold a hearing, but it's possible to abuse that discretion, and that's what he did here. And then in terms of whether the state cites that there's a pattern of appellate rulings authorizing this type of evidence, I dispute that, but even on these cases that the state is citing, they're not McDaniel challenge cases. They're cases where the evidence wasn't challenged, and that's just part of the sufficiency of the evidence. There's some expert talking about that. Frankly, even if they were McDaniel challenges, that would only show that the court had upheld contested evidence on an abuse of discretion standard. It wouldn't mean every court from here on out has to admit that evidence. But so I would say that was error. I do ask that the court reverse the judgment and either remand or reverse and dismiss or do some sort of combination of those two.
Thank you, counsel. Well argued, well briefed. It'll be taken under advisement. I think that concludes our docket, Madam Clerk. All right, we'll be adjourned until tomorrow morning. Thank you so much.